Welcome to Estate Planning with Bernard Law.
Welcome to Estate Planning with Bernard Law and attorney Daniel R. Bernard, founder of Bernard Law PC, serving clients across Long Island. Dan focuses on creating customized estate plans designed to protect your assets, minimize taxes, and make sure everything is handled the way you intend. I'm LeAnn Lyon, and today we are talking about what actually happens after someone passes away in New York and how the estate process unfolds step by step. It's good to see you again, Dan.
Great to be back, LeAnn.
So, Dan, what are the first steps that need to be taken after someone passes away in New York?
So what I typically tell people is take a beat. You can grieve your parent. You don't have to start the legal process. I've unfortunately I've received calls from where I can hear the beeping in the background, and I say, when did your parent pass away? Oh, the doctor said it'll be within the next couple hours. Okay. I usually say, well, why don't you spend the last couple hours of your parents' life with them and then call me back. But after we've properly grieved our parent, the first step would be to determine, did my parent have a will or did they not have a will? What assets do they have? Did they own a house? We want to start going through their mail, and start seeing the bills coming in, and what if they. You really have to determine how have mom or dad left me. Some people, mom or dad have left them in a great situation. You have a trust in place, and you don't have to listen to this podcast, because this podcast is for people that didn't put a trust in place. And other times you'll have mom or dad just did a will, they thought that was enough, or mom and dad didn't do anything. And now you're in an administration process.
So, speaking of that, how is it determined who has the legal authority to act on behalf of the estate at the beginning of the process?
So many times people will come in and say, "Oh, I'm the executor of my mom's estate." I say, "When did the surrogate appoint you?" "Oh, I haven't been." "What are you talking about?" "I'm in the will. I'm the executor." Whoever's in that will is not the executor. Only one person in Suffolk County can appoint someone as an executor. Only one person in Nassau County can appoint someone as executor, the surrogate. So that person in your will is the nominated executor. They actually have to bring that will to the surrogate's court with a probate petition, with a filing fee, and petition the court to be appointed as your executor. So the person that's first nominated has the first right to be the executor. If someone is behind them and the first person doesn't want to do it, they certainly can step in and say, "I want to do it," but they have to have that first person waive the right to do it, or give notice to them and give them an opportunity to come to court and say, I'm not going to do it. If we don't have a will, now there's many people that are entitled to be the administrators of your estate. Preference would be given to a surviving spouse first, followed by kids. But even a creditor can be an administrator of your estate. If you owe money to Visa, for example, and your family never starts a probate, Visa can start a probate too. If they think you have or an administration, they can start that and say, "We want to be the administrator. We think this person had assets and they owe us money, and we want to be able to take control of that estate, sell that asset, and pay ourselves back." So that's very rare. Typically our family will do that first, but that can come about.
That's wild. I've never heard that. But I do have a quick follow-up question. You said spouse is the first and then kids. Does it go in age order of the children to kind of go through them?
That's a great question, man. It's not an age order. It's typically whichever child will apply to the court first will get preference. The best thing it would be if your kids could get on the same page and say, "Okay, you do it, and we'll all consent to you doing it." That's going to make the process go faster. But if there is if the court has to decide, that's going to add a lot of time and a lot of expense to the administration, forcing the court to pick an administrator.
So what determines whether an estate needs to go through probate in New York or can be handled just completely outside of court?
It really depends on the assets that are in the estate. So for essentially when we pass away, our assets are in two categories: probate assets, non-probate assets. Non-probate assets are anything that has a beneficiary designation, anything that's jointly owned, or anything that's held in trust. If something's jointly owned, goes to that joint account holder. If something has a beneficiary, goes directly to the beneficiary. If something's held in trust, the trust controls what happens to that asset. So our probate assets are only the things that don't have a beneficiary, are not jointly held, are not held in trust. For 99% of us, it's really just our house. And even our house, upon if we own it with our spouse, typically that house is not a probate asset upon the first of us to pass away, because I owned it with my spouse jointly, and now my wife just owns the house 100% by operation of law when I pass away. But I'll give you a caveat there. I have a wife now who's probating an estate because the house was just in her husband's name. And we still have to do a probate. Just because you're the spouse does not mean you automatically get the probate assets. We still have to prove that this is the way the assets are supposed to go.
So once probate is required, what are the key steps involved in that process?
So key steps with probate: we need to get the original will. We can't probate copies. We need that original. Hopefully, mom or dad have kept it in a safe place, like in their house, in a waterproof, fireproof box. Or hopefully maybe mom or dad's attorneys have held on to that will in a vault, which is becoming less common, as that was older firms were doing that, and we don't see that as much nowadays. Or hopefully they've left that will somewhere where you know where it is, because if we can't find that original, that's a big problem, because the court presumes that mom or dad destroyed it on purpose, and that to essentially revoke it. So we're not going to be able to probate the copies. Need to find that original. We need an original death certificate. Sounds silly, but a lot of my probates are delayed by we can't get the original death certificates for whatever reason. Usually we see that if it's a probate that's been lingering, it was grandma's estate that they never did anything. Grandma died 20 years ago. No one has a death certificate. So that's we have to get the death certificates. And then you may have to get waivers from the other beneficiaries. That will make the process go faster. If you can't get the other beneficiaries to sign waivers that they're waiving their right to contest that you're going to be the executor, waiving their right to contest the will, if you can't get them to sign those waivers, you're going to have to get the court to issue citations to have them come to court. So that's going to add time and expense to the probate. And then if you have a will that's just an estate that's going to just one person, so our families with the only child families, the complication there is the court is going to ask for a family tree to ensure that that was the only kid, that there was no other people out there. So you're going to need to get an independent person to put a family tree together for this family. So depending on your situation, there could be more things or less things that we need. But ultimately, we have to put all that stuff together and submit it to the court. And then whatever they ask us to do, we have to do after that. So sometimes they're going to tell us, cite more people, cite the tax department. Sometimes they're going to tell us, do the family tree. We have whatever they tell us to do, we have to do it to get appointed as executor. It's the way it goes.
And so what does that person, the executor handling the estate, actually have to do as the process moves forward?
So they have to marshal the assets. So they have to collect all of your assets. Typically, they're going to sell everything. So if you have a house, they're going to sell your house. They're going to collect your bank accounts, your IRAs, 401ks, life insurance. Typically, that is non-probate. Your executor, it's not their job to deal with that, and they don't have to. So sometimes I get executors that tell me, my siblings are really busting my chops about this IRA, and when are we getting the money? And do I have to do this for them? I have to fill out all the forms for them? I say, no, you don't have to fill out the forms for them. They have to fill out the forms themselves. They have to collect the forms themselves. They're a beneficiary. They have to do that. But as an executor, you have to collect all those probate assets. So that's going to be bank accounts. It's going to be selling the house. Maybe it's closing down a business. But those are going to be your jobs initially, is get all the assets. Then your job is going to be, you have to pay all of the final debts that the decedent had. So they might have a final medical bill. I'm sure they're going to have, that last visa bill, last tax bills. and you have to, we pay all those final expenses, and then we account to all of our beneficiaries. So we tell the beneficiaries, hey, here's all the money I took in, here's all the expenses I had, here's what your share is going to be. That accounting could be informal, which is easy. Yeah, here's everything I did. Just sign off on this. I'm going to send you a check in the mail. 9 times out of 10, we can settle estates that way. Everyone's happy. Everyone gets the most amount of money that way. Sometimes we have siblings, for whatever reason, they don't want to accept an accounting. And now we have to do a formal judicial accounting, which is more time consuming, more complex, more expensive for the estate. But ultimately, that's asking the judge to settle the executor's account. That's asking the judge to say, hey, here's all the money I took in. Here's everything I paid out. Here's what my commission's supposed to be. Here's what the beneficiary's supposed to be. And we're asking the court to review and sign off on that. The beneficiaries can contest it. But ultimately, once we get the court sign off, we're going to distribute the assets and hopefully do some estate planning so that we don't have to do this when our kids don't have to do this when we pass away. We can avoid probate. But that's the whole process.
What are the most common issues that slow down the process or create complications?
When we can't find the will, certainly slows things down. When we can't find the death certificate, certainly slows things down. The family trees can slow things down because we have to find someone that can attest to all of that. Yeah, I knew this person for 40 years. They were my neighbor, and I never saw any other kids in that house. I was friends with them. They only had that one kid. That was it. Sometimes that can add some delays. Sometimes the delays are with the other beneficiaries. A lot of times in an estate, this is our last chance with siblings to litigate our sibling rivalries because mom and dad are gone now. The glue in the family is gone. This is my last chance to bust my brother's chops and vice versa because there's no other time that they're going to be able to do that. So a lot of times we just see siblings that don't like each other and they want to waste their parents' money on litigating against each other, or they have bad feelings about, well, mom left me less money in the estate for XYZ reason. I'm not signing any waivers. You got to do everything the most complicated way. You got to send me citations. You have to do a formal accounting. I'm not going to sign off on the informal accountings. Those can add delays, but that's the beneficiary's prerogative. They're entitled to the judicial accountings. There's nothing wrong with that. They don't have to sign waivers. They're entitled to citations, but it's going to add delays. It's going to add expense.
So without those complications, what does the timeline typically look like from start to finish?
So what we've been telling people now is that probate's typically from beginning to end a 15-month process on average. It's the problem there is, the courts all around, they're working incredibly hard. I'm not saying that the court, the people in the courts aren't working very hard, but it's an overwhelming job, right? Because, and I know COVID, it feels like it was so long ago, but it really was only 6 years ago. And, in COVID, we have to remember, we lost a lot of people. So the courts we had a perfect storm for the courts, right? Because you had a lot more people dying and no one could be in the court working. So work obviously, is slower pace when we're working from home just because we can't have the collaboration, whatever else, right? So we had a little backups there. We're getting past those backups, but still, it can be 6 months before someone's appointed as an executor, and that can be 6 months of waiting to close on the sale of a house. I like to use houses as the best example because that's in most estates. That's what we're selling is the house. And in this real estate market of the last 6 years, you can sell a house in a weekend, right? And it's just how fast can the person close? So your kids, when they're the beneficiaries, they want to be able to close as fast as possible because when they close, they get the big check. But more importantly, they don't have the liability of that house anymore. They don't have the expenses of that house anymore because oh, my kids have to wait 6 months to sell. That's 6 months more electric bills, six more months of taxes, 6 more months of if the pipes freeze, if something bad happens in this house, 6 months of your house sitting vacant and people knowing your house is vacant, and maybe your kids live in the same town, they watch the house. Maybe your kids live in California and they can't watch your house. So those kinds of things can be a problem.
Can you briefly walk us through an example of how this process played out in a real situation, including where things went smoothly or where issues came up?
Sure. So the smoothest possible ones are, when people come in and I'm meeting I'm meeting all the kids at once. Those are my smoothest probates. And I've had estates like that where they come in, you meet everyone. Older brother, older sister raises his or her hand. Oh, I'm the executor. I'm the executor. And the other ones, yeah, that's mom and dad always knew, or, the eldest was the most responsible, or, make some kind of joke. But we're all on the same page, right? We're all signing waivers. Oh, you're the executor, but I'm going to help you clean out the house. We're working collaboratively, right? I don't need this. I don't need this. I don't need that. We want to do this fair. Though I've had plenty of families like that. It goes very smooth. It goes very fast. And it's really just how fast can the court appoint us as an executor, where it can kind of, I had a situation where it was smooth with the family, but the problem was just the probate delays, just because the courts are backed up. The realtor sold the house that weekend. That first weekend, the mom passed away. They probably put the house on the market maybe a month after mom passed away, right when they're making the probate petition, and the house was sold that weekend. They couldn't close on the sale for 8 months until the court actually appointed the executor. Unfortunately, that was the time when our interest rates went from 3% to 6%. Does it matter for the people in the estate? No, it didn't matter to them because they got the same purchase price. They were locked in, but to that buyer, their mortgage payment's an extra $1,000 a month because we couldn't close in that 8 months. Again, does that matter to the estate? No, but where it would matter to the estate is we were fortunate that the buyers could still afford the property. But there's many estates at that time that lost their buyers because the buyer could not afford the house at a 6% interest rate. So now you're back to square one, restarting the process. So, and we've saw that a few times when we had those interest rate disparities where people had to start over the process, lost their buyers, and you got a lot of hard feelings there too. So that can certainly be a problem. And then on the negative side, typically it's when the siblings can't get along, it really only comes up towards the accounting. Once we get the person appointed as executor, the siblings really can't do anything until we get to that accounting process. And I've seen siblings say, my sibling isn't entitled to a commission. Well, New York State statute says your sibling is entitled to a commission, so they're getting it. I've had estates, well, my sibling spent too much money on this. Well, you can nitpick, certainly, but in those accountings, it's really only going to be the stuff that's pretty egregious. I think we can argue about how much it costs to clean a house, right? But if in the will, I'm getting mom's condo and I use estate expenses to paint and clean out that condo and refurbish the condo, which I've seen happen, and then I want the estate to pay for that, that's going to be something that's not going to be approved. And that's where we see accounting contests that are successful.
Excellent. Well, thank you for all of that great detail. And to our audience, thank you for being here. That is for today's episode of Estate Planning with Bernard Law. If you'd like to learn more about Daniel Bernard and, more importantly, how to put a plan in place that makes things easier for your family than what you heard about today, down the line, visit BernardEstatePlan.com. Thanks for listening, and remember to like, subscribe to the show, and share this episode with someone who might need it. Thank you, Dan.
Thank you, LeAnn.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.